Okay, my name is David Jones, Deputy General Counsel with Texas Realtors. So I have this presentation here. Um, the first few slides deal just in general with the settlement. I'll go quickly through those because I know most everybody wants to get to the forms and you might have a ton of questions dealing with the form. So I want to kind of get to that. That's the good part. Okay, so March 15th, I think everyone knows I don't have to go all the way back last 4 years, right? The NAR antitrust settlement lawsuits. March 15th, NAR entered into a proposed settlement agreement. Part of that settlement, there was a release of liability for basically everybody. Local associations, NAR, MLSs that chose to opt in and agree to the terms of the settlement, and every single individual member as well. Part of that, offers of compensation are prohibited from being issued on the MLS. There's requirements for written buyer agreements. We'll get into all of those in detail. Timeline, August 17th is the date where MLSs should be implementing all of these changes. Okay, here is sort of a summary of all the changes. I know it's a lot of text on a slide. So basically, I'll just kind of summarize. 1 through 4 are all dealing with MLS. Offers of compensation have to come off the MLS. Okay, that includes the actual field of buyer agent commission. No agent remarks, no private remarks. You can't get creative. You can't try and take a picture of a number 3 and put that as part of one of the pictures. You can't do any sort of workarounds. All compensation is off the MLS, and that includes any other third-party platform that is using MLS data. Okay, that third-party platform cannot be then used to aggregate data and recreate what the MLS is doing. So whether it's on the MLS or whether it's using MLS data, no more compensation through MLS platforms. Number 5, no filtering out or restricting MLSs based off, or no restricting listings based off of level of compensation. So you give your client the whole list of properties that meet their criteria, regardless of compensation. I get it. One of the frequent questions is, well, what if the buyer doesn't want to see all of the properties? They only want to see the ones that are offering compensation. You still give them the list. Okay. And then once you give them the list, then you let the client pick which ones they want to go see. But realtors should not be filtering those out beforehand. So the no filtering rule is still in play. Number 6 and number 7 actually go into detail on those with the slides. Next slide. Compensation disclosures. Broker compensation not set by law, fully negotiable, and you have to disclose to the seller and get the seller's authorization if there's going to be offer of compensation to the buyer's representative. Okay, the Texas Realtors forms, I will just tell you, we have incorporated all of these rules into our listing agreements, our buyer rep agreements. So if you're using Texas Realtors representation agreements, you are in compliance with all of this. Okay. The written agreement with buyers requirement. So you must have a written agreement when working with a buyer before touring a home. Each one of those words has a specific meaning. So working with a buyer, what does that mean? That means you're providing brokerage services to a buyer, right? Basically, are you representing the buyer's interests? So identifying properties, negotiating on behalf of the buyer, presenting offers, all of that stuff is working with a buyer. That does not include listing brokers. Okay, that's a common question. Listing brokers holding an open house for your own listing. You do not have to get written agreements with every single buyer that walks in. And that is because you are representing the interests of the seller. So you do not meet the working with a buyer criteria requirement. That also includes subagents, because a subagent would also be representing the interests of the seller. Now, subagent is tricky here because, we found that subagency is really a highly misunderstood concept in agency. In Texas, we do not have non-agents. Okay, so you can't sit neutral in the transaction. You have to pick a side. You have to represent somebody. Okay, so you are either representing the seller's interest, you're representing the buyer's interests, or both under the intermediary provisions. But you have to represent somebody. So if you're the listing broker, that one's easy. You represent the seller. If you already have a buyer rep agreement with the buyer, that one's easy as well. You represent the buyer's interest. Some of the questions that we get are like open houses when somebody other than the listing broker is holding an open house. Do they have to get buyer representation agreements? And my question back is, well, who do you represent while you're doing that? And sometimes people will say, well, no one, I don't represent anybody. And that's not one of the choices. You have to represent somebody. So if you are going to say that you are a subagent is, it's more than just a word. You can't just say I'm a subagent. It's about your agency. It's about your fiduciary duty. It's whose interests are you protecting? So a subagent is just like the listing broker. You are representing the interests of the seller. That is why a subagent does not have to get a written agreement signed with the buyer, because you are representing the seller. But you have to really consider what that means. Take, for example, the, confidentiality. If you're representing somebody's your client, you have to keep their information confidential. So let's take a look at, imagine the following scenario. You're the listing broker. You're sitting at your own listing, an open house, and a buyer comes in and they just love the property. They're not holding back. They're saying, we have to have this property, and we're willing to offer whatever it takes to get this property. It's perfect. We have to have it. You're the listing broker. What do you do with that information? You're probably going to go and tell your seller, right? We got a very interested buyer. We're probably going to get a good offer in. They're willing to pay whatever. Great news. Because you represent the seller's interest, that's not confidential. What about if the other side? What if you were the buyer's agent? You had a signed buyer's representation agreement. You're sitting in the car and now you're having this conversation after you viewed that property, right? Obviously, you're not going to go tell the seller that because you represent the buyer. You have to keep that information confidential. Okay, so what if now we take that scenario of you're hosting an open house, but you're not the listing broker, and you're trying to figure out, am I a subagent while I'm doing this, or do I represent all these buyers that are coming in? Well, are you going to keep their information confidential? If you're a subagent, you would have to tell the seller what all these buyers are saying, right? And if you're having a problem with that, saying, oh, there's no way I would ever do that, that's great. Guess what that means? You're not a subagent, right? If you plan on keeping everybody's information confidential, like instinctually, you are representing these buyers. Which means if you're representing these buyers, you're sitting at an open house, not your listing. If you're representing the buyer's interest, that means you are working with the buyer under this requirement, and you would have to get a written agreement signed by all these people coming through the open house. Okay, so trying to figure out if you're a subagent or not, the duty of confidentiality is a really good test to figure out who you represent. But you got to know who you represent before you head out to that property. And one last thing with subagency, you have to get the consent of the listing broker for subagency. So you can't, an agent cannot just go around the state of Texas saying, I'm a subagent. You have to get consent. Touring a home, so working with the buyer before touring a home, that just means when either the buyer or their agent physically enters the property. Okay, that includes like a virtual tour. So if you're walking around with like an iPad and the buyer's on the other end watching you walk around the property on the iPad, that still counts. NAR uses the word touring. You know, they're speaking to a national audience, so sometimes they don't use the same lingo that we do. We would call this obviously as a showing, is the way we would say it here. So if you're showing a property to the buyer. And home means a 1 to 4 family residential dwelling. So this does not apply to commercial properties, does not apply to vacant land. We get asked about farm and ranch. It's possible it applies to a farm and ranch property if it's got a 1 to 4 family dwelling on the farm and ranch property. Okay, NAR is not making a distinction. You know, the farm and ranch, we might use a different contract here in Texas, but if a farm and ranch property has a house on it, that's still considered a home for these purposes, which just means that you would have to get a written agreement in order to show the property. Otherwise, everything's the same. You're still using a farm and ranch contract. It's just that if it's got a home on it, you would have to get a written agreement. Okay, that written agreement with the buyer's got to have these 3 things in it. It's got to disclose the amount or rate of compensation the broker will receive. That amount or rate of compensation must be objectively ascertainable, so it can't be open-ended. Okay, so basically you need a definite number there. So it can't be a range. It can't be like a general statement, my fee is whatever the seller is going to pay me. It can't be from this amount to this amount. It's got to be a definite number or definite rate. So it can be a definite percent of the sales price or a definite flat fee, but it's got to be something specific. The third one is it's got to have a term that prohibits the participant from receiving compensation for brokerage services from any source that exceeds the amount or rate that you agree to. So you need to have that conversation with the buyer, talk about what your fee is, okay? Do your value proposition, explain to them all the things you're going to do and why you are, you know, more than worth what you're going to do for them, but you have to put a number in there that's what you're going to get paid. And you can't get paid more than that. The next question that we get from that is, well, can we amend it later? Yes, you can. So if you put one number in there and then later on you find out that there is additional compensation or that the seller or listing broker is willing to pay more, can you go back and amend it to that higher amount? Yes, you can do that. But keep in mind, an amendment has to be signed and agreed to by the buyer. So if your buyer doesn't agree to it later on, you know, hopefully you did all this work and your buyer will be appreciative of that. But if the buyer says, no, I think you're getting paid enough, then you're stuck with what was originally in the agreement. So really just what all these rules are doing, it's putting the buyers and the sellers sort of in the driver's seat of compensation. They need to know what they are paying for these services, and it needs to be clearly spelled out. Okay, so I went over this offers of compensation prohibited within the MLS. You can still offer compensation outside of the MLS. Okay, and you can use whatever creative marketing ideas as long as it's not in the MLS and it's not using anything that is pulling MLS data. So you can put it on signs, you can put it on, you know, the little writer, the little sign on top of the big sign. Brokers, you can put it on your website as long as it is only your own listings. Even if you are pulling an IDX feed and, you know, you have that search function on your website, you can still have compensation. That's like a little carve out. So anybody else can't have MLS data coming and then aggregate all, you know, a bunch of different brokers. But if your broker's website, just your own listings, you can have compensation on that website. Okay, so let's get into, so that's sort of, it's broken down into, so you have all of these new rules that are coming down the way. And now you have these forms, and the forms have been changed. And so, we have to kind of marry the two together. So what are the changes that you got to do? And then where do you put the information on the new form? So we're going to kind of marry those two together. Basically, the 10,000-foot level view of what's going on here is this. Previously, compensation was handled primarily one way, right? The seller pays the listing broker one fee, and then within that fee includes an amount that the listing broker is then going to pay to a cooperating broker, buyer's broker, if they're the procuring cause of the sale, right? And that was primarily the way it was done. That was not the only way it could have been done, but the MLS system and the offer of compensation, that the way that it worked was just so efficient and so easy, it kind of became the primary way that compensation was done. Well, that's now gone. Offers of compensation are off the MLS, period. And so now what we've done is all the other ways that compensation can be handled are now put on the table. So it's all about consumer choice. So that's what we really need to kind of understand, is that that's really all we're doing. There's lots of different ways that this can be handled. And so the forms and the contracts have been modified, yes, to comply with the rules, but also we've got all these options now. And so we need to have deeper conversations with buyers and sellers and get them to understand there's multiple ways that this can be done, and pick the one that works best for all the parties. So June 24th, actually just exactly a month ago today, we rolled out the new forms. So we got amendments. We updated listing agreements, buyer rep agreements. We created a new buyer rep agreement, the short form. There's an addendum to the contract, and we updated our compensation agreements. And I've got images of all these, so we'll go through these one by one. Okay, so the amendment to representation agreement. This is a temporary form. It's form number 2701. This has one purpose and one purpose only. So if you had a listing agreement or buyer rep agreement before the new forms came out on June 24th, those older forms do not comply with the new settlement requirements. The new settlement requirements have to be in place August 17th. So if you were using an old listing agreement, and if your client goes under contract to, whether they're on the buyer or the seller, if they go under contract before August 17th, you're good. You don't have to change that listing agreement or that buyer rep agreement. But if you are still working under an old version of the listing agreement or buyer rep agreement, and August 17th hits and your client isn't under contract yet, well, now those new requirements kick in. So you need to amend it so that your listing agreements and buyer rep agreements are in compliance. And that's what this amendment does. It does not change any other terms. Okay? You can't use it for any other purpose. It's one shot. All it does is get them into compliance with the new rules. The other way to do that, you could just sign a new version of the listing agreement or buyer rep agreement. But we created this one for an easy one in case you didn't want to go fill out, all 11 pages of a listing agreement. Once some time has passed, this is temporary, so we're going to pull this down once we feel, we're past the point where people are still working under old versions. That is one of the reasons why we put these forms out so early, over a month ago, because we're hoping that there won't be too many listing agreements and buyer rep agreements that are still out there, the older versions, and your client hasn't gone under contract yet. Okay, so this is the big change we made to listing agreements, and we've done it to 3 of them. It's again, these are residential. The settlement deals with residential. So we, commercial brokers, we haven't changed any of those. Leasing, this does not impact leasing. This is all about sales contracts. So we did change. So the residential exclusive right to sell, residential exclusive right to lease, in the farm and ranch again. NAR is not making a distinction with farm and ranch and residential, so it is still possible for a farm and ranch property for us to still be wrapped up into these requirements. So these are the 3 listing agreements that we changed, and they're almost identical. The leasing provision has a little bit different the lines for compensation. It's not based off of a percentage of a sales price. It's based off of, percentage of monthly rent. But pretty much they're identical. So this agreement is where the transaction starts, right? The whole process starts when an owner of a property says, I want to sell. They call up a broker. Will you list my property? This is where it all begins. So the first choice, that this is like a fork in the road. So how is the compensation going to be handled from the seller side? Well, the seller can continue with the previous way, the traditional way, give the broker an amount of compensation, and that amount includes some for the buyer's agent, for the listing broker to pay over to the buyer's agent. Okay, that's going to be box 5A. That's the one you've been doing all this time. The difference with 5A and why it looks different now is that bold portion 5A2, that's where the compensation that's going over to the cooperating broker, the buyer's broker, that used to be in a completely separate paragraph. And so we have, for transparency purposes, we've moved it up. It seems natural that conversation should happen at the same time, so that you're talking about what the broker's fee, total broker's fee, is going to be, and then what portion of that is the listing broker then going to share with the other broker. As you can see, one of the other aspects is, yes, we put all of those different choices are now on the table, but also we wanted to try and be as transparent as possible. That was kind of the underlying problems with the lawsuit in general, is that, consumers were saying, we didn't know. Seller didn't know that they were paying an amount that was going to the buyer's agent. Why would they do that? That they're not working for me. So we made sure that we kept it in here. You may have heard on the news that other states are removing the offer of compensation. Again, we chose to go with consumer choice. We didn't want to be the ones deciding for consumers what they wanted to do. So we put both choices up there, and we made it blatantly clear that there's a choice, right? So you got 2 boxes, 5A or 5B. 5A is with compensation to the other broker. 5B is just paying the broker's fee without compensation for the other broker. So that's sort of the fork in the road at the very beginning. A lot of what happens with the other forms and the choices later on will depend on which way the seller chose to go. Okay. Are you paying listing broker pays the other broker, or are you just paying the listing broker? And now with 5B, if that's the choice, we believe that if that's the choice, that the next thing that's going to happen with compensation is that on the buyer side, because the buyer's having the same conversation with their clients, right? The buyer's going to say, well, if the listing broker is not offering compensation for my broker, I want to ask the seller. And they can do that through a number of ways. We'll go through those forms as well. That I want to ask the seller directly, will you offer compensation for my broker? And so that's what that note is down at the bottom right under 5B. There's nothing to fill in. It's just letting this, it's helping the listing broker have that conversation, so that the seller, you're telling the seller, hey, You have chosen to just pay me, which is fine. That's what you want to do. But keep in mind, when the offers start coming in, there's a very high likelihood that the buyers are going to ask you to put some money towards their broker's fees. And if that's the case, so now the next question is, seller, are you willing to contribute? Do you want me to tell the other side that you're willing to contribute? And so that C paragraph 11F for broker's authority, that's what it's talking about. 11F is where the seller can say yes or no. I want you, my listing broker, to tell buyers and buyers agents that I'm open to at least considering contributing some to the buyer's expenses. Now, there is a difference between seller contributing money to his buyer's expenses and the listing broker's offer of compensation. The listing broker's offer of compensation, you already have authority for that, to advertise that, to disclose that. Okay, that's kind of why the seller wanted 5A to begin with. They want everybody to know that this is what I will pay the buyer's broker. But if it's 5B, you don't really know what the seller's intentions are. Do you want to pay, or you want me to say something? What's going on? So we made sure that you had to get that specific authorization. So if it's 5A and the listing broker is offering compensation, you do not need any further authorization. You do not need 11F. But under 5B, you want to make sure if the seller wants you to tell everybody they're open, you need to go down to 11F, and that's that little box at the bottom of the screen. It's just a simple checkbox. Seller does or does not authorize broker to share with other brokers that the seller's open to contributing.
Ask questions.
Your questions at the end, please.
The next form or the next conversation, and just in generally the way we tried to design this paragraph is, you're going to be sitting with the seller having this conversation. We wanted this paragraph to aid in that conversation, almost like a blueprint. So it kind of follows the flow of the conversation. And so the next thing that came up from this is like, okay, seller, you want me to tell everybody you're open. What about a specific amount? Do you just want me to say in general, yes, the seller's open? Or do you want me to tell them, yes, the seller is open, and here's an amount that you can submit with your offers? And this also came sort of at a request from MLSs across the state. Several MLSs are, updating their platform. All of them have to take off compensation, and many of them are then putting on a seller concession field. And there's no uniform way that that's being done. Some MLSs are not doing it at all. I'm not sure what you guys are doing. Some are not doing it. Some are doing it. Some will just have a checkbox. Yes, seller concession. No seller concessions. But some have an actual place to put in a number for seller concessions. And so because it was sort of all over the map, we didn't want to put a number or a blank line for a number in the listing agreement. We felt that would cause confusion on areas that don't have that option. So what we did, we do have a separate authorization form that can be used. And this is 1412. It's got sort of a long name. Seller's authorization to disclose and advertise certain information. It's not a new form. We just updated it. So paragraph A there, you see, has that blank line. That is only if the seller wants the listing broker to name a specific amount that the seller will consider, buyer to pay for buyer's expenses. And if you're working in an MLS that has that field, you can use this to get that authorization, because the MLS is probably going to want to see this, get that authorization that you have the authority from your seller to put a specific number in there. If you're not going to get a specific number, you don't need to use this form. So it's not required. And this number, make sure the seller knows they're not obligated to this number. They can still negotiate it when the offers come in. So that's why there's a lot of bold here that talks about that. You're not obligated seller, and that if you are working with an MLS that offers that, you can put that number in there. Okay, this is the amendment to the listing agreements. This amendment is sort of a universal form. It's for all of our listing agreements. And Texas Realtors, we have like 6 different ones. We got a couple of residential, we got the farm and ranch, and we have 3 different commercial listing agreements. And this form was very basic because it's used for all of them, you know, but they all got different terms. So we had to keep it kind of simple and basic so that it could still be used for all of them. Well, the update we wanted to do was, we felt that with all of these new options being on the table, that compensation is going to change a lot from what you originally agreed to till later on. So we wanted to make sure that we gave our members an easier way to change compensation after the original listing agreement is signed. But the problem was that we ran into, just from a legal drafting sort of perspective, is because we got so many different listing agreements and they all have different structures of their compensation. We couldn't put all of them on there. So we wanted the most common ones. So TXR 1101 and 1201, that is the residential exclusive right to sell and the farm and ranch, because it's identical. So we put those 2, so you can use paragraph C and D to amend the broker's fee in those listing agreements. C is for the total broker's fee, and then D is for the offer of compensation going to the other broker. And under C, you can switch from 5A to 5B. So if it started off as 5B, you can switch to 5A or vice versa. If you are working with a listing agreement that is not 1101 or 1201, you can still change compensation. You would go down to paragraph F. That's sort of the catch-all there. So you can put whatever the paragraph number is, and you can just type in whatever the change is. And in fact, that's what you did before. We put compensation on this form anyway. So for the other listing agreements, it hasn't really changed. And if you wanted to change any other paragraph that's not one of these pre-printed ones, you would go to paragraph F. Okay, representation disclosure 1417. This is not a new form. It's been updated. We beefed it up a little bit to make the language a little bit stronger. This is specifically, it's for, a law in the Occupation Codes, the Real Estate License Act, that you're required to tell the other party who you represent upon your first contact. You could do it in writing or you can do it orally. So all of you have been doing this all the time, right? Without even knowing. When someone walks in and you say, "Hi, my name is David Jones. I'm the listing broker." Done. You cite it. When you call somebody up and say, "Hey, I have a buyer. I represent the buyer." Done. Right? You've complied with it. It's a fairly easy thing to comply with, and you're already doing it. But in case a broker or agent wanted something in writing as proof that they did it, we have this form available. Well, an issue came up that some brokers had an agreement or some type of disclosure that they wanted to make sure that there was no implied agency going on, that they wanted to make sure that this other person that they were talking to understood that I represent, like, say, the seller. I'm the listing broker, and I don't represent you, and I don't want to make any mistake. So we beefed this up a little bit with that language. So we added paragraph C that basically explains agency and fiduciary duty. And then that acknowledgement in bold at the bottom that just says the undersigned person acknowledges there's no agency relationship. All right, let's switch over to the buyer rep agreement. This is the older one, which we have now renamed. We just tacked on the word long form. That's just to distinguish it because we now have two buyer rep agreements, one short form, one long form, but this is the one that you've been working with. Okay, TXR 1501. This one had a little bit more extensive changes to it, primarily because the buyer representation agreement had those three specific requirements I talked about at the beginning. So that bold language right at the top, right underneath the number 7, broker compensation, those are the disclosures that have to be in there per the settlement. And the broker is prohibited from receiving compensation for broker services from any source that exceeds. We talked about that. But we also have that language that anything that you put in here has to be objectively ascertainable. So it's got to be a definite amount. So we don't have any other like blank lines to put compensation in here, and that's intentional. So you've got percent, for purchases, percent of sales price or a flat dollar amount. For leases, it's percent of 1 month's rent or percent of all rents paid over the term or a flat fee. Okay, so it's definite. You can only put definite amounts in this form now. We do get asked a lot about bonuses. We tried to put in a blank line in our earlier version. We used to have blank lines for additional compensation. But we felt part of sort of one of the underlying principles when we're drafting forms is risk reduction. We don't want to put a form out there that our members can get in trouble if they're not using it correctly. Right? Whether, we don't want to lead you astray and lead you down the wrong path. And so with the settlement, we're still in the preliminary approval phase. We don't get final approval. We didn't want to take any chances and put our members at risk for violating antitrust, for violating the settlement, we still have the Department of Justice is carefully keeping an eye on the real estate industry. So we're not taking any chances. So there's only blank lines to put definite amounts, and we don't have any kind of open-ended paragraphs like we have in some of the other agreements. Like the listing agreement, there has blank lines in it for you to come up with a creative compensation structure that we maybe didn't think of. We can't do that on the buyer side because it has to be objectively ascertainable. So one of the questions we get is bonuses, right? Can you get a bonus? Yes, you can. But in order to meet the objectively ascertainable requirement, you have to know what the bonus amount is. You can't just generically say, I'm entitled to all bonuses, or I'm entitled to a bonus from this amount to this amount. Those do not meet the objectively ascertainable specific amount requirement. So the only way we can really come up with your ability to retain any bonuses is we had to put that on an amendment to the contract. So that once you know that there's a bonus, like once your buyer has identified a property and they're going to submit an offer on a property that has a bonus, that's when you pull out the amendment, and now you know what the bonus is. You can write that amount in, and you can write the property address in so that the buyer can then see it, and it is a specific amount, and the buyer can agree to it. Now, it's probably a good idea to kind of prep the buyer for that at the initial conversation, right? When you're talking about your services, you're talking about your value, all the things you're going to do for the buyer, you bring this topic up so that if the buyer does select a property with a bonus, when you pull out the amendment to ask them, is it okay? I want to make sure I got your authorization that I can receive this bonus here, that they have already been prepped and they like your services. They agree that you're totally worth it and that they're going to sign the bonus. sign the amendment for the bonus. But the only way is you got to know what that specific amount is before you get the buyer's agreement to that. And I've got an image of the amendment. We'll get to that. Okay, this is the new one. This is the buyer representation agreement short form. This form was specifically written overwhelming member request. You know, our normal buyer rep agreement is 5 pages long. It's a great, it's a great agreement. We didn't create this because we don't like that one. We wanted to give our members options. Okay, so this one is in addition to the long form. It does not replace it. It's not required. You can use the short form. You can use the long form. I know a lot of brokers are creating like policies for their brokers and their agents about use of which one they want to use. That's fine. Okay, it's not a required document. But what we ran into, and this was part of our task force that we gathered from brokers, large and small, medium brokerages across the state, and that having that conversation with the buyer right at the beginning and getting them to immediately sign a 5-page agreement is difficult. Like some buyers just don't want to sign. That relationship is a different relationship from the seller. Like the seller, they own the property. They know it's a big deal. So the listing agreement is like 11 pages long. They have no problem signing an 11-page agreement to sell their property. But a buyer, a lot of times they start off, they just are looky-loos. They just want to go drive around and look at properties. They're not necessarily ready to commit to a long-term representation agreement with at that point, a stranger, right? You haven't had a chance to, sell your value and talk about your expertise and your experience yet. So, this one is great for that hesitant buyer who doesn't want to immediately jump into a long-term exclusive relationship. So instead, you have a 1-page document. It's much more easier to swallow for a consumer than throwing 5 pages at them. Now, obviously, from a legal standpoint, you can fit a lot more legal stuff. That's a legal term. I learned that in law school. You can fit a lot more legal stuff in a 5-page agreement than you can a 1-page agreement. So it doesn't have all the same protections that the 5-page agreement has. But we feel, it's a basic agreement. It'll get the job done. But again, if you really want all the extra language in that long form, by all means, use the long form. This agreement is basically 2 agreements in one. So it will be able to do like your full services that you're normally used to. You help a buyer from the beginning to the end, help them find the property, submit the offer, negotiate, repairs, talk to their lender, help them out with that, and sit down at the closing table. But because of the new requirement that you have to have an agreement with the buyer just to show a property, we felt that we needed something even simpler. Okay, that is the showing services option. So under paragraph 5, there's simple check boxes. So broker can pick, the broker and the buyer, or tenant, but I'll speak to the buyer here. The broker and the buyer can agree to full services. Okay, what you normally do. The new part of this is showing services. That first line you can see after showing services, paragraph 6, 7, and 8 do not apply. That's the rest of the contract. So you basically stop the agreement at paragraph 5. So it's a 5-paragraph contract now. All you're agreeing to, and all the client is agreeing to, is to provide access to properties. So you're showing property. We included a simple flat fee. This is a new service, new thing. So we're going to kind of wait and see and play out. I know I've heard that some some brokers might want a more like complex type of fee structure, like a price for every property type deal. You can still do that. You can like add an exhibit, add a fee schedule or something like that. I would advise getting an attorney to draft something simple up just to add to this. But for right now, we're trying to keep it simple and basic. So we just did a flat fee. It's due upon execution of the agreement. A common question we get is like, well, how do we collect? How does that work? Okay. That's going to be your broker policies and procedures. That part of it doesn't go in the contract. So, this is not required, but I have heard some fairly creative ideas. I've heard brokers say that you can create like a Venmo account, PayPal account, the ones that you can pay over your phone. You can create QR codes from those. You could put a QR code on like a business card or some type of, marketing pamphlet that has, how great your brokerage is. And you could have a QR code down on the bottom so that an agent can meet a buyer at the property, scan it with their phone, and pay whatever agreed upon fee. And because the broker set it up, that amount goes to the broker. Right. And it does say the client will pay the broker. So that's just one, one idea that I've heard of, but that's up to sort of brokerages to come up with the policies and procedures regarding, what kind of forms of payment are you going to accept? How are you going to get the payment to the broker? Make sure that the agents are reporting all of this. Those are broker policies and procedures. And so we've tried to make this, especially the showing services, we've tried to make it simple. It's a basic contract. We've tried to make it flexible so you can use it in all different scenarios. One of the brokers in our task force described it as, okay, so we're going on a first date versus getting married. That's what the showing services are. So you've got this new requirement that you have to get a written agreement signed with this buyer before you show the home. They're not ready for a full commitment of an exclusive long-term, representation agreement. So this one has so much flexibility. If you look at paragraph 3, it has the market area. So you can define what the market area is. It does not have to be a big, huge area. It could be one property address. The term, how long does this agreement last? It could be 1 day. We also get asked, what about showing services, a fee? Can we charge 0? Yeah, you can put 0 in there. Okay, you don't need money for consideration to make it a binding contract. There are promises that the buyer, that the parties are making. Okay, so you can put 0. So you can do one property for 1 day for no money. And it's a 5-paragraph agreement. Okay. That will, literally and figuratively get you in the door with this client if you need a written agreement in order to show this property. What you can then do is you have that one-on-one time with this person to build that relationship so that when that buyer does want to submit an offer, they'll come back to you. At least that's the plan. And if that does happen, if you chose showing services, now you're going to have to amend this agreement. Because so far, if you choose showing services, you've only agreed to open doors for them. But if a buyer says, okay, well, I'm interested in this property, can you help me submit an offer? Absolutely. Here, let's talk about the agreement. And you can either switch this, you can continue on this one. You can switch it from showing services to full services. We do have the amendment allows that. Or now that you've built up that trust and they want to go with you and use you to buy a property, you can pull out the long form, the 5-page. If you like that instead, but now you have that relationship. So now you're not throwing out 5-page contract when you just met them at the property. All right. It's all about choice. It's all about flexibility. It's trying to provide the forms that our members, need to conduct their business in the way that they want to. Texas Realtors does not want to direct compensation. We don't want to direct, business models. So we're providing all of these various options. But if you're going to use showing services, it's important to understand that's all you've agreed to. So it is possible for this person to agree to showing services. You take your time and your gas and you go out there. And then if they choose to buy that property with somebody else, they can do that. They're not tied to you after that. But if you understand that that's what the agreement is, we feel that this agreement can be used, by members. It will satisfy the requirements, but it will be especially useful for, like the open house situation I mentioned before. If you got a lot of people coming in and you need a written agreement with all of them, you can even have like a stack of these by the front door with just that property address, just that day, showing services, 0 fee, and you're satisfied the requirement. Okay. Finally, before I move on, I also want to make sure I point this out. This is a representation agreement. Okay. Again, no such thing as non-agency. In Texas, you can't remain neutral. You have to represent somebody. And this will get you representation of the buyer. Now, there was a lot of confusion to this when this first came out because, especially on the buyer side, representation was always the full thing. And people really didn't consider like, okay, I'm just going to do this one part. I'm only going to provide this one service for you as part of my representation. There are limited service listing brokers that only agree to like put a property on the MLS, but they're not going to do much more beyond that. Okay, that is still that's a legal form of representation in Texas. You can limit the services that you're going to provide, but while you're providing those services, you still have your minimum duties. You still got your fiduciary duties, but you are not required to then go all the way to help them buy the property. Sit down at the closing table. You can agree to a contract to limit what services you provide. While you're providing those agreed upon services, yes, you have minimum duties to comply with. Okay, here is the amendment to the buyer tenant representation agreement. We added several paragraphs C, D, and E. C is specifically just for the short form 1507. So you can easily switch from full services showing service or showing service full services. If you started off as showing services and then you want to switch to full, you have to consider intermediary. You do not need intermediary authorization for showing service, even if you show your own listings. Okay. Intermediary authorization doesn't kick in until that buyer wants to start talking about submitting an offer on one of your own listings. That's when you would need intermediary authorization. So it's in the short form. It's paragraph 8. It's way down here at the bottom. Okay. It's just a simple checkbox. Client does or does not authorize intermediary. And if you're switching from showing services to full services, well, now before you only had that small flat fee, right? So now you have to put in the compensation for the full thing. Again, you can switch from full showing to full, keeping it on the short form, or you can start with showing services. And if they want to use you to buy that property, you can pull out the long form 1501. Either one works. So I mentioned about amending it. So if you start off with one level of compensation on your buyer rep, but now you find out that there is more compensation and your buyer is willing to amend it and agree to it, that's where you would use D. So you change what the total broker's fee is. And if you find out there's a bonus later on, that's where you would use paragraph E. Okay. All right. Compensation agreement between brokers, 2402. This was a little used form, and this might probably be the most used form going forward. The compensation when it was on the MLS, a lot of members didn't understand that actually created legally binding contracts. When the listing brokers put a number in there for buyer agent commission and the buyer's agent came and they were the procuring cause of the sale, that created a legally binding contract through the MLS without the brokers ever having to sign any kind of agreement to that. Well, we lose that agreement. Okay, with compensation not on the MLS, we lose the ability to communicate that to everybody. Right? We talked about that. You can put it on your website and on signs and all that kind of stuff. But we also lose that automatic agreement between brokers. This is what replaces it. But now, instead of that agreement being automatic, you're actually going to have to execute a document. So listing broker, cooperating broker, you have to execute this. All right. And we simplified it because we did feel it was going to be used pretty much all the time on every single transaction. We did incorporate the earned and payable in order for the cooperating broker, the buyer's broker, to be entitled to compensation. You have to meet the earned and payable definition. So earned just means your client goes under contract with the listing broker's property. That's earned. To be payable, you got to be the procuring cause of the transaction. Okay, so we borrowed that language and we put it in here. So it's the same standard. So the same standard that you're used to, compensation through the MLS, is the same standard. So we're continuing that. So cooperating brokers, you know if you're entitled to compensation if you're the procuring cause. Listing brokers, you have to pay if the buyer's agent is the procuring cause. If there's disagreements, disputes over procuring cause or not, same way we handle them now through the MLS. We have the realtor arbitration you can go to. Obviously, it's legally binding, so you could go to court, but the realtor arbitration is a lot cheaper. It only costs $400 for each person to start that. An important difference that I want to make sure everybody understands, you have to sign this agreement. Okay. Before, when there was compensation on the MLS, a buyer's agent could come, show the property, submit the offer, never have to really sign anything with compensation. They just got to say, I'm the procuring cause, you owe me the commission that was on the MLS. You cannot just be the procuring cause and be entitled to compensation anymore. You have to get this agreement or another agreement. I know some brokerages might have an agreement. You have to get an agreement signed first, even if the broker has something on their website. I'm paying this compensation to buyer's brokers. You can't just walk in, submit an offer, and say I'm procuring cause, because the contract aspect of the MLS is gone. So even though this agreement has procuring costs in it, you first have to actually execute this. Now, again, some brokers have said they can put this on their website, like partially filled in. You can put this on your website so that other brokers can see it. You cannot put this on the MLS because it's compensation. Okay. All compensation is off the MLS, but could you put a copy of this on your website? Sure. Okay. Addendum regarding broker's fees. Okay. This is the last one, and then I'll take some questions. Addendum regarding broker's fees. This is actually an addendum to the TREC sales contracts. Okay. The ones we've been talking about before, like listing agreements, that's the broker and the seller signing it. Buyer rep, that's the broker and the buyer signing it. The compensation agreement, this one here, that's broker to broker, listing the broker and cooperating broker signing that one. This one is the buyer and the seller signing it. This one actually becomes part of the sales contract. Okay, not a lot of the Texas Realtors forms actually change the sales contract. This one does. This one, it's complicated again because there are so many different ways compensation can be done. We put them all on the table, so the form needs to address all the various ways that compensation can be handled. So first let's start looking at paragraph B, fees. We get questions about that. Cash fees as specified in this addendum will be paid in, blank county in Texas. That's kind of legal stuff. People ask, well, what do we put in there? That's for if there's a dispute later on and somebody needs to file a lawsuit, where do you file a lawsuit? Where you have to put where performance was supposed to happen. Where were the fees supposed to be paid? So it could be the title company, it could be the property, it could be, listing brokers, office. It could be any one of those. But if you're, working in Austin, Texas, you don't want, and that's where the property is, you don't want the listing broker saying, well, I'll give your money in El Paso. So come out to El Paso and get it. Right. So you just want it somewhere, some county close to where all the action is happening. Paragraph C, the listing broker's fee. Most of these, like the listing broker's fee, it's just more informational for the title company because this is going to be attached to the sales contract. So on the 1-4 contract, it could also be used for unimproved property and for the Trek new home contracts. The only one you can't use it for is farm and ranch. The reason is that farm and ranch already has its own, broker fees paragraphs within that contract. But obviously the 1-4 is going to be the more popular one. So most of this is just informational for brokers, for the title company, to let them know that, hey, we have these other agreements going on for dealing with brokers' fees. We got listing agreements, we got buyer rep agreements, we got compensate, we got all this stuff going on, and you're letting the title company know. And then down at the bottom, paragraph E is the authorization. So you're telling so the seller and buyer are signing this, and the seller or buyer are telling the title company, we're giving you our authorization to disperse commissions based off of what we put in this agreement. Okay. So paragraph C, listing broker's fee, just says that that's going to be in the listing agreement. D is the other broker's fee. That's the buyer's broker. It's called other brokers because we have to mirror the language in the 1-4. In the 1-4, they use the term other broker, so that's why it's there. But that's the buyer's broker. Now, the buyer's broker can get paid a lot of different ways now, and they're all on the table, so they're all in here. That's why it looks so complicated, right? So first you have the buyer. It should have a buyer representation agreement where the buyer said, I'm going to pay my own agent. There's no blank line for that one. You don't need a blank line. It's just a heads up that to the title company, there's this other agreement out there. But first, either the seller or the listing broker might be paying the buyer's broker fee as indicated below. So that's where the check boxes are. So D1, that's if the listing broker is paying the buyer's broker. Okay, so through a separate agreement like 2402, like the compensation agreement. That used to be what was done through the MLS. It's not going to be done through the MLS anymore, so it's going to be in a separate written agreement now. That is pretty much the same thing on like the 1-4 contract, page 10. That little disclosure at the bottom of page 10 where it says the listing broker has agreed to pay the other broker, and then it's got a blank line for a fee, right? That's the same thing. D1 is the same thing as that. D2A, the first one under that, is now the seller is going to pay. 2A is where there is a separate agreement. We have, just like we have the compensation agreement between brokers, we've got another form, the compensation agreement between broker and an owner. So it is legally possible for the buyer's broker to sign a separate contract with the seller. I know it kind of sounds weird because the seller's got their broker and this is the other broker for the buyer, but it is still legally possible. So we're not saying that that's the best way to do it. We're saying that's one of the options. So we're leaving it on the table. So that's 2401. The other way that the seller can pay the buyer's broker is through the sales contract itself. So within the 1-to-4 contract. That is 2B. That one is different than everything else because that one is a brand new agreement. The other ones point to other agreements. 2402, 2401, the listing agreement, the buyer rep agreement. This one, D2B, is a brand new obligation where the seller and the buyer are agreeing as part of the terms of the contract that the seller will compensate the buyer's broker, whatever you put in there. And why that's important is when you fill in that one, this becomes the contract now for that one. The rest of them, it's just informational. Hey, title company, we've got these other agreements. But that one is different because it actually creates a new term in the contract. The question we get most about that is like, what about paragraph 12, right? You got paragraph 12 where the seller's paying buyer's expenses. How does this one work with that? This is a separate term from that. Paragraph 12 is the seller paying buyer's expenses. Buyer's expenses has a definition. And that definition has, loan origination fees, appraisal stuff. It's got a specific definition that does not include broker fees. So you can't just put a number in there and that's going to get paid. That's going to go to broker's fees. That is separate. So if the parties are going to agree that the seller pays the amount specifically to go to the broker's fees, this is the only form that does that. And that's D2B is the one that does that. Could you have numbers in both? Yeah, you could. You could have some number in paragraph 12, which is going to go towards buyer's expenses, appraisal and loan and all that stuff. And you could have an amount in D2B that's going to go straight from the seller to the buyer's broker. That is possible, but those are two different terms. Okay, so that is all. That's the last form I'll talk about. I can answer some questions. I know that's a lot. I'm sorry. I know there's a lot of forms. I will, before you get to questions, the legal hotline is available Monday through Friday from 9 a.m. to 4 p.m. The attorneys that man the legal hotline, they know all the same stuff that I do. Keep in mind, we do have to answer questions generally, so we can explain the contracts, but one thing we can't do is tell you what to put in that blank. So we'll talk to you about this form and the compensation, but as soon as somebody says, okay, what do I put in here? We have to apologize and say, I'm sorry, we can't do that. So just trying to kind of set expectations. We can't tell you what to put in there, but we will explain it so that you will know what to put in there yourself. Also, we have a website. We have a page dedicated to like the lawsuit and the settlement and the forms changes. It's texasrealestate.com/lawsuit. texasrealestate.com/lawsuits. It's got all sorts of FAQs on it. We've got two how to use documents that we put out, how to use the two new ones, how to use 1507, the short form, and how to use 2406, this one. that's got some examples in it. We've got flow charts. So we understand this is a lot. It's big changes for the industry because you have the practice changes and you've got form changes at the same time. So we're really trying to put out, as much training, as much material as we possibly can. And we're continually doing it. So legal hotline, and check out that website. Other than that, I'm ready for questions.